Welcome back to the channel. I've had a number of different questions about using mobile phones whilst driving in all sorts of different permutations of the question. But a few of them just recently have revolved around filming or taking photographs, and specifically whether filming for YouTube or Instagram or TikTok or anything else is permitted. Now, there are a number of different things to take into consideration here, not just the regulations themselves for using mobile phones, but also the generic application of law vis-a-vis careless driving, dangerous driving, driving without due care and attention and consideration for other road users, and so on. Not to mention having full and proper control over the vehicle. So in this video, I would like to talk a little bit about those regulations themselves and what they mean, and what interactive communication might mean, what handheld might mean, what driving might be taken to mean, and one very interesting case of Barrister, which went up to the Court of Appeal, in which one of these issues was debated and ultimately ruled upon by the Court of Appeal by way of case stated. That was when the DPP, the Department of Public Prosecutions, appealed this by way of case stated, which I'll come back to in just a moment. So as I said, the overall position is that you must always be driving with care and attention. You must not be driving carelessly and certainly not dangerously. And indeed, one thing that a lot of people fall foul of is that driving carelessly or dangerously might come about depending on how you use a mobile phone or anything else for that matter. So first of all, we'll look to the Road Traffic Act of 1988, which is a broad, overarching piece of legislation which provides reference to the road vehicles construction and use regulations and the amendments thereof. Section 41D of the Road Traffic Act provides that a breach of the requirements as to the control of the vehicle and mobile telephones, etc., which is referenced to these regulations, specifically provides that a person who contravenes or fails to comply with a construction and use requirement, this is those regulations that I'll come back to in a moment, in that A, as to not driving a motor vehicle in a position which does not give proper control or full view of the road ahead, or not causing or permitting the driving of a motor vehicle by another person in such a position, or B, as to not driving or supervising the driving of a motor vehicle whilst using a handheld mobile telephone or other handheld interactive communication device, specific wording of which, as I said, I will come back to in a moment, or not causing or permitting the driving of a motor vehicle by another person using such telephone or other device, is guilty of an offence. So this gives broad reference to those regulations, which have been amended a couple of times. Now, specifically following the Barrister case, which I will briefly overview now, in the case of Barrister, essentially the driver was filming a collision with his phone, and initially convicted in the magistrates. This was overturned by the Crown Court in that the argument was made that he wasn't using it for interactive communication, he was just filming the collision, and quashed the conviction. The DPP then appealed by way of case stated to the Court of Appeal. The Court of Appeal agreed with the Crown Court judge in that, in its conclusion, it said that it follows that the activity of the respondent, this was Barrister the driver, did not come within Regulation 110, and the Crown Court was right to quash the conviction. However, there were then, as you might have guessed, subsequent amendments, and by way of statutory instrument, which is a bit like legislation, but a statutory instrument typically has a very specific purpose, relating to the Regulation 110 of the Road Vehicles Construction and Use Regulations of 1986, specifically relating to mobile phones and other handheld devices, was amended by this statutory instrument, which came into force on the 25th of March of 2022. The main changes thereby were as follows. Regulation 110.4 was the removal of the requirement of a driver to be using a mobile phone or device to perform a communicative function, meaning that should the driver be using a mobile phone or device capable of transmitting and receiving data, whether or not those functions were enabled, they were still contravening the regulations. Regulation 110.6c was the expansion of the meaning of the words using for the purposes of these regulations, in light of what I've just said, making clear that under the use now under these regulations, any such actions, even checking the time, notifications, unlocking a device, and these kind of things were all expanded into the use of this device. Thirdly, Regulation 110(5)(b), inserting a new defence relating to making contactless payments for mobile phones or other devices whilst driving. But this was specifically intended for things such as paying at a drive-through, using your phone to make payment, and those sort of things. You should be in park, you should be stopped, and that is limited for that purpose. And of course, retaining an exemption for emergency services. And as is often the case with law, you have to look at various bits together to get the full picture. So in this case, you've got the Road Vehicles Construction and Use Amendment number 2, which was the one coming into force on the 25th of March 2022. But also, for much more detail, was Amendment number 4, which was coming into force all the way back in 2003. And then, of course, Regulation 110. To understand the full regulations and what they mean. But looking specifically at those amendments that were made in March of 2022 are things such as follows. Under paragraph 3, in relation to mobile telephones, instead of the word performs, it's been substituted with is capable of transmitting and receiving data, whether or not those capabilities are enabled. So whilst initially performs suggests that it is actually being used for such a purpose, for transmitting any kind of data, but instead that's been substituted with is capable of transmitting and receiving. So whether or not those are enabled. So you could be holding it and not actually using it, but if it's in your hand and it's capable of doing so, that then means you are in breach of these regulations. Immediately afterwards, of course, is that exception that I mentioned, which is contactless payment, but that's of course provided that you are stationary in accordance with paragraph 3. But then of course comes the biggest list of amendments, which makes this a whole lot broader, which essentially means you're breaching the regulations if you do any one of these things, which are all encompassing. So sticking under paragraph 3, but under specific subparagraph D, substituting the word using from the main legislation with the following. So now it would include illuminating the screen. It would include checking the time, checking notifications, unlocking the device, and of course making, receiving or rejecting a telephone or internet-based call, sending, receiving or uploading oral or written content, meaning you could be speaking to the device, sending, receiving, uploading a photo or video. So this would come to answer some of the broad questions about using a phone or any other device which is connected to the internet, or even transmitting it to some other device, whether or not to the internet just within your car or with your car itself perhaps. Anything that's used for the purposes of live transmission, let's say it's YouTube, let's say it's TikTok, or any other kind of streaming platform. If it's being used for any of those purposes whatsoever, you cannot have it in your hand. And that comes to the handheld bit that I'll come back to in just a moment, because that is also fairly important. Utilizing camera, video, or sound recording functionality, again, encompassing what I've just said. Drafting any text, so that includes, therefore, the drafting of a text message, whether or not you're actually sending that text message. Creating a draft comes now within these regulations. Accessing any stored data, such as documents, books, audio files, photos, films, videos, playlists, notes, or messages. So accessing pretty much any content on your device. Accessing an application. Now, clearly that encompasses every application on the device, and accessing the internet. That obviously covers accessing anything on the internet. And just to be clear, application is also further defined as meaning any software program that runs through a web browser or offline on a mobile telephone or other device. So this would include your watches, this would include any kind of smaller device that runs any kind of app and any kind of software. So using any device for any of these things on a handheld device comes within these regulations and will immediately put you in breach of these regulations to attract a significant number of points, typically 6 points and a £200 fine. Now, we come to what we really mean by a handheld device. But here is where it might get very slightly frustrating for many of you, because the term handheld is not specifically defined. So all of those things are restricted and will put you in breach of those regulations, attracting 6 points on your driving license if caught. And remembering, if you've got 6 points already and you attract another further 6 within a set period of time, you will be up to 12 points within that period of time, and therefore you'll be facing a driving ban unless you can show exceptional hardship. But the problem is this: Regulation 110 does not define handheld. Although within those regulations, Regulation 110.6a states that a mobile phone or other device is to be treated as handheld if it is or must be held at some point during the course of making or receiving a call or permitting any other kind of interactive communication function. And interestingly, paragraph 42 of the Court of Appeal Barrister judgment also talks about a device being handheld. The judgment provides at paragraph 42 that the provision has the effect of treating as handheld, for the purposes of paragraph 1 of the regulation, phones and other devices by reference not to the way that they are designed, but to the purpose for which they are being used and the way in which they are being used. They are to be treated as handheld if they are or must be held at some point during the course of making or receiving a call or performing any other interactive communication function. However, this is a point that is not absolutely defined in law, although this is a very broad interpretation, both by the regulations as they stand and by the Court of Appeal judgment. And I suggest that any case that comes before the court to argue this point, the argument is going to rest upon whether at some point that device must be held to perform that function. And so the argument might be that if you are not holding the device and it's permanently fixed and you absolutely cannot hold it in the hand, then it might be the case that the court finds that it's not handheld for the purposes of the regulations, because it can't be, because it's permanently fixed, at least in terms of where it is at that moment in time and cannot be removed, and it simply isn't being held in the hand for the purpose that you are using it. So in other words, if the phone or other device is in a cradle and it cannot and need not be removed from that cradle and held in the hand for that function, then the court may be on your side in that it isn't and it need not be in the hand for the purposes that you're using it at that moment in time. Because the wording of the regulation and of the Court of Appeal is fairly firm. Either it is or it must be held at some point during the course of that function. Now, this comes with a word of caution, because the word held doesn't necessarily negate it being in a cradle, in my view. In my view, you could be holding a device whilst it's in the cradle, because if you are holding on to the device with one hand, tapping it with another, there's a very clear argument there that you are holding that device, irrespective of it being within a cradle. Obviously, being in a cradle puts you in a slightly safer position, but ultimately, I think it's quite likely that at least one or two cases like this are going to come to court, and it's going to be determined whether or not a phone in a cradle being used in such a way will be interpreted as being handheld for the purposes of the regulation. Now, all that aside, you remember that I mentioned at the opening overarching principles of driving with due care and attention, consideration for other road users, and not driving dangerously. Now, irrespective of being in breach of these regulations, if you were using a phone for, let's say, several different purposes whilst in a cradle, it is still quite likely that you might be challenged for driving without due care and attention, i.e. careless driving and even dangerous driving, depending on what you're doing. But how does this and how might this relate to using a fixed camera or a phone for that matter to filming you whilst you're, creating YouTube videos such as this? I myself have toyed with the idea of taking cameras into the car to do driving and talking type videos whilst I'm out and about in the car to talk to you about various legal issues. Now, broadly speaking, I don't see a problem with that, provided, as I said, the phone or the camera or whatever it might be is permanently fixed to wherever it is. It's not causing an obstruction. You don't need to interact with it whilst you are driving. And remember, driving can include being in stationary traffic with the handbrake on, even if you've got one of those cars where the engine turns off, auto start, stop, or whatever they call it from different manufacturers. You are still driving for the purposes of the law, and therefore if you're interacting with that device, I still think there is a risk, even if it is still fixed to the windscreen, that you might be criticised for that, depending, as I say, on the level of interaction and whether it must be at some point held in the hand. So if it's the case that you must take it off to make an adjustment and then put it back, then it's the case that, in my view, you must have it held in the hand at some point before putting it back and then continuing. However, if it's the case that you, as I know some YouTubers film whilst they're driving, they set it before they leave, it's recording, they're out driving, talking to camera, provided that the attention is not taken away from the road to such a degree that it's driving without due care and attention, careless driving, dangerous driving, which I would hope that it wouldn't be for those people that are doing that. And certainly most of the cases that I've seen are doing that. It's not the case. There are one or two very questionable videos I've seen on TikTok where someone has literally been live streaming and interacting with that live stream, even though it's in a cradle. This is a clear example that I'm making that it doesn't matter whether it's held in the hand physically or not, even though it's in a cradle, because the interaction is to such a degree, it is most certainly in those cases careless driving, if not dangerous driving, because of the amount of time that the person's attention is taken off the road and onto the device. So live streaming and reading comments, irrespective of whether the device is in a cradle or not, I would say are an absolute no from my perspective, because your attention is almost certainly taken far too much off the road onto the device. You should not be doing that. You should not be watching your screen, reading comments from your screen on any kind of live stream and things like that. However, if it's just the case that it's filming you whilst you are driving and you're commenting to camera, it's recording you so that when you get back, you stop your car, you're parked, you finish driving, then you turn off the camera, you take out the card and you take it to upload and edit and whatever. Personally, I think that's okay, because you're not holding it in the hand, and it's not the case that it must be in the hand at some point to perform those functions. Whereas for the normal run of things, if it's a phone for making phone calls, absolutely make sure it's in a cradle. Do not take it out of the cradle. Don't hold it while it's in the cradle, irrespective of it being in the cradle, because as I say, my view is that if that comes to court and you are holding it even though it's in the cradle, my view is the court will see that as being a handheld device, even though it is also being supported by the cradle. So that's my warning in that sense. And otherwise, more generally, as I've had lots of you comment just recently, those that drive many miles, even driving on hands-free, if you're driving using the phone, it's distracting you from the road. So talking to camera, I think, is less distracting than it would be on the phone. Just as you would be talking to a passenger would be less distracting than talking to someone on the phone. Because by the very nature of it, the phone is an extension of your physical space. It's connected to someone else, somewhere else, and in my view, that's taking your attention off the road, much more so than it would be for your passenger or talking to camera. So those are my views on that. Those are my thoughts. That's a brief overview of the regulation. I've done one or two other videos on this before. You can check those out. I might link those in the description as well. But I'm sure there'll be more questions, more comments, more thoughts. Let me know what you think. Any other questions? Please do remember to like this video and subscribe, as it really helps my channel grow and to reach a wider audience. In the meantime, thank you very much for watching, and I'll see you next time.